the Elder Law Out Loud podcast. I'm Carla Ray here with the CEO and founding attorney of Family First firm, Jeff Hotzen. And today we are talking about probate. And a lot of people seek out our advice once they become a personal representative. What does that mean? It's a job that is sort of thankless, but you do get paid.
You can get paid.
You can get paid.
Absolutely. So, a personal representative in Florida is what they call an executor in a lot of other states. I feel like often people hear the term executor, they know what that means. Oh, it's my responsibility to represent. Well, actually, a lot of people probably don't know what that means.
Yeah. You find out on the fly
That's
once you're in it.
That's it. So, but the concept of an executor is truly what a personal representative is. Florida just has a lot of different words. They use different names for a lot of different sorts of positions and documents and all kinds of things. Honestly, it's a little unique in the legal sphere.
Florida man.
But the personal representative, that executor, is their job to represent the estate. Okay, act on behalf, if you will, of the person who passed away, and ultimately carrying out their wishes if they have a little, carrying out the Florida statutes that they did.
Okay. So personal representative, that's something that exists in the probate process, whether there was an estate plan or not.
That's correct.
Okay. How does one become a personal representative?
Appointed by court. So, the judge has to say this is the person who's going to be the personal representative. It does not matter what the will says, actually. Now, I say that with some caveats that the judge is going to give preference to who's named in a will. And in fact, in our statutes, there's an order of preference or priority as to who would be named if there is no who's named. But the bottom line is the judge has the ability to say, yes, this person was named, and so I'm going to appoint the personal representative. Could they not appoint the person? Yeah. There's a few basically the bottom line is the person has to qualify to be the personal representative. They can't have been a convicted felon. They need to be a resident of the state of Florida, or if they're not a resident of the state of Florida, they need to be related by blood or marriage to the person who passed away. So early in my career, I took a probate where a guy passed away. He named his girlfriend, lived up in Vermont. They spent time up there and back down here in Florida. He named her as the personal representative of his estate. I petitioned the court to have her appointed. And of course, said, no, we can't, because she's not a resident of Florida. And she's not related by blood or marriage to the decedent, the person who passed away.
Okay.
Yeah.
So what happened in that case?
His estranged son, who he wrote out of his will, was a person who then petitioned to serve, and he kept the thing wrapped up in probate for years.
So the bottom line is you want to have an estate plan in place so that, things go smoothly, for your heirs and maybe so that people you have disinherited
don't end up controlling.
Yeah. So once the judge appoints the personal representative, what happens next?
Well, that person's required to be represented by an attorney. Excuse me. The attorney is really going to guide them through the process, but their job is to marshal the assets of the estate, is what they say. So basically that means they go out, figure out where everything is. Is there bank accounts, savings account, retirement accounts, real estate, personal property, cars, you name it. Get all that stuff together. In some cases, it's selling the home or maybe a piece of rental real estate. It could be liquidating an investment account into cash, kind of pooling those assets and then giving a report or accounting to the judge saying, hey, here's everything that's there. Then it's their job to pay off any creditors that exist. So if you're in a situation where maybe somebody passed away, they had some credit card debt, medical bills, end of life, those people are entitled to be paid before anybody goes that your beneficiaries, the people you left behind. So creditors get paid first, and then anything that's left over, then the personal representative's job is to distribute that out to the beneficiaries. Okay. That's a real quick summary of what that looks like. But
I've heard people say that, my loved one knows that they're dying, so they're racking up a bunch of credit card debt.
Yeah.
It's all going to get paid eventually.
If it goes through probate, yes. So that's the key, because that's where creditors have rights. If things pass outside of the probate process, whether it's through irrevocable trust, beneficiary designation, things like that, those creditors oftentimes then end up they're holding the bag, so to speak.
Okay. Yep. Not that we feel so bad for the major.
No, really not. No, not at all.
We want to see, we want to see the families, benefit from what these people have worked for through their lives. Okay, so someone's named a personal representative, they marshal everything, they pay off the debts. Then are they also distributing the money to the heirs? And how are they told how to do that?
So if it's pursuant to statute, generally, the statute's going to be clear about where it goes. Sometimes you'll petition the judge to give you direction on that. If it's in a will, generally same thing. It'll be clear. Hey, I want a third, a third, a third. If there's any ambiguity, you may, file a petition for basic clarification, saying, hey, I want to make sure that we understand who the beneficiaries are here. Judge, make sure everybody's rights are being protected, so that when I distribute, I'm not on the hook for doing something wrong. We do see that sometimes. It's not very common. And in fact, one thing I'll say is that, over the last couple of years, there have been pushes to change some of the probate statutes. And this year, we did see that change. In May, that, we are going to, I think, see a change when the laws go into effect in July, that we're going to be able to do summary administration more frequently, which you don't need a personal representative for. It's kind of open and shut, all at once sort of probate. They're trying to give personal representatives more power and jurisdiction. The ability to. What we see sometimes is smaller institutions will get an order of administration or letters of administration and say, I don't really know what this is, so I'm not going to let you access these funds. So then the personal representative goes back to the judge, gets an order directing this particular organization to give them access to money or whatever it is they need to do. Our statutes now are basically going to say, hey, if that person requires you to do that, they're going to be on the hook for your fees, your attorney fees, for improperly denying that. So, getting more access to safety deposit boxes. So they're trying to even expand and broaden the powers of the personal representative.
So when that law change happens in later this year, is that going to fundamentally change how we do our work here?
Not really. What you'll probably see more frequently is more summary administrations than formal. Right now, the barrier for summary administration is basically you file a petition and an order at the same time, saying, Judge, there's no debts of this estate. The total estate value is less than $75,000. And because of that, we want you to sign an order directing that these funds go to whoever they're supposed to go to. So if there's a will and there's three children, and that's where it's supposed to go, judge signed an order distributing these to three kids. A personal representative is never appointed in that case. The judge signs the order. You take a certified copy of that order to the bank. The bank says, okay, here's a check for Jimmy, a check for Bobby, and a check for Susie. And boom, 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 there you go. It's closed and done. They're doubling now to 150,000. So before it was less than 75, now it's going to be less than 150,000, which means that you'll be able to have more people do summary administrations, which are shorter, cheaper, and more efficient. So it's definitely good for the residents of the state.
So length of time for an average probate case that's a formal administration right now is about how long?
8 to 12 months.
Okay. And summary administration?
2 to 3, depending on what county it's in, how quickly the clients get the documents. There's some things that play into it. Once you file the case, once it's filed with the court, we normally see orders signed back between 4 to 6 weeks. So, that's from filing to getting the order. And some counties will get into some same day. It's very infrequent.
Which counties are those?
Because you can't go county choosing anyway, so
Right.
It doesn't matter. But yeah, for the most part, you can expect multi-weeks, and it depends on how busy the judges are as well.
Okay. In those summary administration cases, are you still required to hire an attorney?
So no, but it's interesting. The statute says whenever it talks about attorneys, it talks about attorneys representing personal representatives. It does not say that they're required in any other situation. And because a personal representative is never appointed in a summary, that necessarily, well, the assumption or the belief is that you don't need an attorney to do the summary administration. Of course, the problem is, the first time any of us do anything, we're probably not going to get it right 100%. It doesn't matter what it is. Like if you're cutting your own hair, the first time you do it, probably give yourself a bowl cut. It's not gonna go
I would
well.
not recommend.
Right. No, don't do it. I can speak from it. No, I can't. I've never done that, but I'm sure if I were, it wouldn't go well. And something like, a probate with, tens or $100,000 on the line, it's probably not something you want to try to just follow.
You're gonna DIY
Yeah,
DIY lawyer it.
that's it.
Lawyer
Lawyering
in
for
for
dummies.
Dummies. Is that a book that
I'm
exists?
sure.
You
You
should
should
write
write
I
it
it
if
if
think
you
you
I
have
have
think
it.
there is a probate for dummies or something like that out there that I saw like very early in my career.
Okay. Okay. So what if you are appointed as personal representative and you don't want to be?
You don't have to. So it's not forced upon you. It's not like if you're appointed, this is a mandate or anything like that. That's also true if you were a trustee on the trust. And actually, to circle way back, if you wanted to name somebody who's not a Florida resident and not blood or marriage relative as a trustee of your trust, you can do that. So if my guy that I told the story about who passed away here and David's girlfriend, if he'd had a trust set up, his girlfriend could have been the executor. And in this case, it would have been the co-trustee, but she could have been the person who had done all that. And his son never would have been able to be involved.
Mhm.
Yeah.
Okay. So assuming that you do want to be the personal representative for some reason, you love control and you want to be that person that's like, oh, I'm in charge of the family estate. You get a kick out of that or whatever. Um, at the end of all of this, you've actually put in a good amount of work. So there's some compensation there.
So under Florida statutes, you're entitled to be compensated 3% of the gross value of the estate. Same as the attorney. Now, attorneys oftentimes will bill more than 3%. But that is what the statutes say is both the personal representative and the attorney are both allowed to charge 3% of that gross value of the estate. So it doesn't matter if you have a home that's indebted or is underwater or anything, like a rental property or something like that, the value of that property, the total value is still included, and both a personal representative and attorney are entitled to be paid first. There's a order of priority, and basically what our state says is, hey, if we don't get the representatives and the attorneys paid first, no one's going to take these cases. And so we're going to make sure that they're paid first so we can actually get these things through the court system. So, yeah.
We have here at Family First Firm some legacy cases, I will say, for probate. What is something that will hold up a probate case and make it drag out longer than the averages that you previously stated?
So, I think depending on the nature of assets, that can certainly change things. I, at one point, had a probate, and this has been many years ago, where the estate included multiple pieces of just undeveloped property, just dirt. You think, okay, not too big of a deal. Problem is, it was down on iDrive, so it's incredibly valuable dirt, and you have some of the most valuable dirt around.
Yeah.
And basically, the dirt was so valuable that when added with everything else, that the estate was taxable. I mean, it had to file the gift tax return and pay, not gift tax, I'm sorry, a federal estate tax return and pay taxes to the federal government. The problem is that the federal government won't accept payment in dirt. And so they want cash. And the point of it is, almost all of these assets were illiquid. And so we had to sell these things. And as you might expect, selling commercial property is not a quick feat.
Yeah.
And so,
And for those who don't know, I drive in Orlando. That's kind of the center of our tourist district. So very important to own property there, if you can, but apparently not so great in a probate process.
not great because we had to sell that stuff. We have to find a developer. And this was, I think, in 2010, maybe. So, property values were depressed. The economy was in shambles. It's not like anybody was excited about buying property at that point. And, ultimately, we had to wait for some property to sell so that we could pay taxes and the interest that was accruing on those owed taxes year after year before we could end up moving forward and closing the estate. So, that's an example. Obviously, if you have beneficiaries who aren't doing what we need them to do, is signing receipts, signing consents, things of that nature, that will certainly drag out the process.
The bottom line is all of this is really avoidable. You said that nobody should be going through the probate process.
Nobody has to. It's a choice.
Okay.
Every single person who goes through probate chose to do that by not doing planning, not sending up beneficiaries, not using special types of deeds. I mean, ultimately, that's why when we do trust planning here as an example, we actually, I always like to describe a trust as call it like a safe. It doesn't protect anything that isn't inside of it. And most attorneys just give you an empty safe. Nobody really wants a safe. What they want is protection. What they want are the results of having that safe. And that's the way trusts work, is nobody really comes here wanting a trust. They want the benefits of a trust. They want to avoid probate for their loved ones. They want to save money on this, on the attorneys after the fact. They want to save the headache and the time and the expense, the frustration that their loved ones are going to have to go through if they go through probate, which is why we do I call it the packing, the legal term is the funding of the trust for our clients. It's not even an option, it's just something that's automatically included because that's the only way we can make sure that that trust is going to give you the benefits that you're looking for, that you came here to hire us for. An empty trust and, hey, figure it out yourself. You remember we talked about the first time you do something, you're probably not going to get it right.
Right.
And so we do this every day for our clients. You've probably never done it once. That's why I think it's so important to work with a organization who will really ensure that you do avoid probate for your loved ones, that your goals are accomplished when that time comes.
This might be kind of an obvious yes, but do you feel that probate is even more difficult for people, obviously, because they are grieving at the same time?
Oh, for sure.
It's got to be the most emotional of cases that we handle.
Absolutely. We had this terrible probate, physician, we were doing a probate for his 19-year-old daughter.
Mm.
And yeah, horrific. He was, to put it gently, he was a difficult client, and one of our attorneys at the time, said he was being mean to her. She said, I'm so sorry you're going through this. I can't imagine what it's like to lose a child. And the guy just sobbed, you know, because his anger was coming from that hurt.
Of course.
And it is incredibly emotional, and it is very challenging for a lot of people. In a time you should be grieving, instead you're jumping through hoops and dealing with lawyers. So it's not it's not anything that anybody should really want to ever have to leave their loved ones to pick up those pieces.
Yeah. And do they have to actually physically go to court? Do we handle all of that for them, or
Very rarely.
Okay.
Very rarely. So that is one blessing, I guess, if you will, that personal representatives almost never step foot in the courtroom. Something has to have gone horribly wrong.
Yeah. You hired the wrong firm? No.
You have beneficiaries who are fighting or something like that,
Yeah.
and it becomes contested. But
Yeah.
yeah, generally speaking, they would never see the inside of a courtroom.
And that happens far too often, that people are fighting over assets and their
Yeah,
inheritance.
it's sad. We say first comes grief and then comes greed. In the sense that everybody grieves differently. And some people grieve by fighting, by grabbing for money that they think will make them feel better, that they'll try to, soothe their wounds with a new pool or a fancy car or who knows, the big trip. And they, look for those funds to be able to make that happen, and they're willing to ultimately destroy relationships with family members in pursuit of that. It's very sad.
Any final thoughts for somebody who maybe found this episode because they are about to become a personal representative and they've just sort of been thrown into this world?
I'd say truly make sure that if you're going to serve, because remember, you don't have to, it's not a requirement. But if you want to serve, and if you're going to do that, you work with someone who can provide you a lot of guidance and handholding, a lot of support, a lot of just understanding. Because it is a very challenging time. You are going to be grieving the loss of a loved one while you're doing this, and that sucks. So a organization or law firm, because you have to have a law firm or an attorney at least, who can provide you, I'll say, grace and emotional support and then just legal guidance during that time. It's incredibly helpful.
Well said. And, we're here to help answer any questions if you have found yourself in the middle of the probate process for the first time. Jeff, thank you so much. And thank you for watching. We'll see you next time for another episode of the Elder Law Out Loud podcast.